Welcome to Estate Planning Beyond the Binder.
Welcome back to Estate Planning Beyond the Binder with Brian Chu, managing partner at OC Wills and Trust Attorneys and a leading estate planning attorney serving Orange County families for over 25 years. I'm Leanne Lyon, and today we're talking about estate planning for unmarried partners in California. Brian, what potential issues come up for unmarried couples in California when it comes to improper estate planning, or for those who have no estate planning in place at all?
I think the biggest mistake people do is when they do is first of all, not doing estate planning, especially when if you have a partner that you trust and, you want things to happen for them if something happens to you, or you want them to make decisions, is that when you're not legally married or a domestic partner with somebody, that partner has no legal rights or remedies. They're not treated as your partner or, your spouse. And there's definitely a number of legal and or financial implications of that if something were to happen to that person, whether that, that partner or spouse, were incapacitated or passed on. What happens, and when you don't have an estate plan, it's not even some of the automatic things that might happen, if you're married. And had no documents. So, not having documents when you have a significant other partner, and you're not married is significant. And, we want to make sure that, that person, if something happened to us or incapacitated, they have the rights to make decisions for us, whether it be financial decisions and or most importantly, medical decisions. And also, in terms of inheritance, if something happened to me, I want to make sure my partner is getting my assets, not my family, because by default, things would go to your family. They would be the ones potentially making decisions for you, and or any money you might have, that's not jointly held with that partner, would go to your family because that partner has no legal rights. And that's the biggest issue. They just have no legal spouse rights. And in California, we're not a common law state. So you could be living with somebody for 20 years, but you still have no legal rights. You are not considered a spouse in any fashion.
So if an unmarried partner is rushed to the hospital without a plan, does the other partner have any automatic legal right to even enter the room or talk to doctors, or are they legally considered a stranger?
Effectively, yes, they're legally considered a stranger. And, I'll be honest, because of HIPAA laws, even to some extent, the spouse, without the right paperwork, they don't even know that you're the spouse. Again, maybe you share a common name and it's common address and they'll assume you're the spouse. But, what if you have a different last name as a spouse? Now, obviously in this case, with partners, unmarried partners, you're presumably going to have different last names. And how would they even know that you have any relationship with this person? And so, beyond the fact that, again, they're not supposed to, due to HIPAA laws, they're not supposed to allow people in the room, let alone get medical information without written permission. Now there is no legal relationship where they might overlook it, because obviously with parents and spouses, they tend to be a little more lax on, disclosing that information in terms of, how much of a stickler they are for that. But certainly with somebody who is, technically unrelated to you, they're even be more reluctant to release information about you, let alone make decisions.
If an unmarried partner actually passes away without a will, the state's intestacy laws usually give everything to blood relatives, parents, siblings, even distant cousins. How often do you see grieving partners get evicted from their own homes by their partner's estranged family?
I hear about it. As an estate planner, we hope, my clients are typically avoiding that situation. Right. But, we hear about that from people later after, when they haven't done the estate planning and somebody's passed on. That's definitely what would happen because, like I said, if you're not on title of the property, if there's a home and you're not on the title of the property and you're not married to that person, legally married domestic partner, you have no rights. And the intestacy laws say that property, all the assets, specifically a home as an example, would go to their nearest relative, starting with parents, brothers, sisters, nieces, nephews, and so on.
For unmarried partners in 2026, the annual gift limit is only $19,000. So, what happens if one partner, say, pays off the other's mortgage or buys them a car? Is that a taxable event in the eyes of the IRS?
I mean, it's not a taxable event; it's a reportable event.
Ah,
So anytime you give anybody, and outside of your spouse, you can give as much money, or you can transfer as much money, because when you're married, you're considered one, for financial and tax purposes. But when you're not married, any gift or of assets to somebody else in excess of $19,000 in any particular calendar year is reportable as a gift. Now, good news is that for most of us, that probably won't matter. We report $1 million gift. It's not taxable. Okay. No one's paying, for most of us, no one's paying a tax on that $1 million gift. Okay. But it does count against us in the long term against our estate tax exemption, which is the amount of money we can have when we die that is not subject to the estate tax. I don't know, fortunately, most of us, we don't have to worry about that, but it is a reportable gift. And, if you're fortunate enough to have a fair amount of money when you pass, it could have a significant financial impact. If that $1 million would have put you over the exemption limit, as a result, your family could, someone could end up paying 40% in tax on that $1 million potentially. But again, while you're alive, it's not going to have much effect, assuming you're not giving away more than, as an individual, more than $15 million away. It's not going to have an effect present day, other than it does need to be reported.
okay. Would you consider it a fatal error to name an unmarried partner in a will but forget to update the beneficiary forms on certain accounts?
Well, the thing is, the will only applies to assets that actually pass through it.
Mhm.
Okay. And so if you do designate beneficiaries on an account, that happens first. Okay. That overrides any will or trust. It doesn't matter what those documents say. If you
Mhm.
designate a beneficiary on a bank account, that's where the money goes. And, that obviously can be, as a way for, if you're not married, or even if you are married, you still need to do it. If you want to make the automatic transfer from you to somebody else, if you don't have a trust, as an example, and just have a will, then you definitely want to name, ideally, you'll name that person, anybody over 18, you'll name that person as a beneficiary, either primary or contingent on that account.
So I've heard that it's recommended for unmarried couples to have a cohabitation agreement alongside of a will. In 2026, how does this document act like a prenup for the unmarried to prevent messy civil court battles if the couple splits or one passes away?
It just gives rights to, obviously, it depends on who's going to actually own the property. Obviously, if you have joint ownership on our property and something happens to
Mhm.
one of the partners, then the surviving spouse gets it. But what happens if that spouse is just, that partner is incapacitated? Okay. So, if there's no agreement, that family, maybe they assume, control of that person's estate. And now there is an issue, because, how does that work? Now they're representing the interests of that partner, of the incapacitated partner, and they might insist on certain things, in order for that, the other partner to continue to live there. And so obviously you have cohabitation agreement. It would be dictated in that case what happens. Okay. Or, even if the desire of the partner, were to pass on and they want their share of the assets to go to their family, but they want to preserve the right for the other partner to live in that, that home unfettered for, some period of time. That's where a cohabitation agreement could also be relevant for something like that.
What no contest or disinheritance language do you include to ensure that the deceased partner's biological family can't successfully sue to take assets away from the surviving partner?
Well, in California, we have, what we call a no contest clause that you put into your trust or will.
Okay.
And basically that clause says that if somebody who's getting something under the terms of your trust or will challenges the validity of the trust or will and loses that challenge, they will be treated as if they're a predeceased and will get nothing. And so by, what we are, in California, especially if you have biological children, you're not having those any assets go, you're having assets, if you pass, go to, somebody that's not your spouse, you're not, that you're legally married to, you do need to disinherit your children in this case, specifically, because if you just have a document where you just fail to address, the fact they are or not getting assets, in California is determined that you forgot about them, and thus they will then be treated, they will typically get your assets at that point. And so you definitely want to have language in your, and obviously you need to have a trust or will to specifically disinherit them, because again, especially if you have children, by intestacy laws, they would be entitled to your assets. And if you're not going to have the assets go to your children when you're not married, you do need to specifically disinherit them in the document, because just failure to talk about it, or obviously not having a document, assumes that the assets would go to the children first before any, unmarried partner.
Got it. Well, as we wrap up here, if a couple is listening right now and wants to be fully protected by the end of the month, what are the essential documents they need to sign to ensure that they are treated like family in the eyes of the law?
In this case, it's the typical estate plan, some combination of a trust and or a will. So they state who's in charge of the assets when they can't be, and how and when the assets are going to go, presumably to the partner. Power of attorney, if that person becomes incapacitated, who can make financial or legal decisions for them. If they can't make it for themselves, again, presumably naming their partner. And then just most importantly, the healthcare directive, who has access to my medical records, because, obviously everybody, we want to make sure that the doctors can talk to your unmarried partner. And then obviously you want to make sure they can then make decisions. And so, because without those documents, that unmarried partner has no rights. And their rights, whatever standing they have is behind direct relatives. And so, if your goal is, if something happens to myself and I have a partner that I want to make decisions for me, I need to have legal documents in place. And, you want to contact an estate planning attorney like ourselves. And we can put those things in place, typically, 2 or 3 weeks, we can have those documents in place so somebody can make decisions for you when you cannot. And that's what estate planning is ultimately. You get to choose, because otherwise, if you don't choose and you don't have an estate plan, you don't have these documents, somebody else is going to make that choice, and it may not be the person you want. And in this case, for somebody who has an unmarried spouse or unmarried partner, they definitely don't have any rights. And so you want to make sure they have legal rights, and documentation is the only way to have it.
Your estate plan is only as strong as the people you trust to carry it out. If you're not sure who to name, or you just want to make sure your choices are still a good fit, Brian and his team can walk you through your options and help you make the right call. Visit www.ocwillsandtrusts.com to learn more or schedule time to talk. Also, be sure to like, subscribe, and leave a review if you enjoyed today's episode. Thank you, Brian.
All right. Thank you. Have a great day.
You too.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.